Good morning, everybody. Welcome all members of the public and all committee members and officers and cabinet member and presenters to this meeting, Licence and Regulatory Committee here today. First item on the agenda, apology for absence.
Chair, apologies from Councillors Hickman, Prosser, Taylor and Ruth Edwards.
Okay. Is there any declarations of interest? Okay. Sorry, members, I forgot to say that this is live, as normal, this is live streamed, and we'll do our normal round of introductions to everybody as this is live, so people know who we are. And the format of the day will be for Paul Keeble to introduce the item that we have on the agenda, and then we'll have a presentation from Robin Carr. My name's Linda Guppy. I'm the chairman of the Licensing Regulatory Committee for today.
I'm Richard Williams, Democratic Services Officer.
Ruth Rourke, Principal Countryside Officer.
Claire Williams, Legal Assistant.
Sorry, Paul Keeble, Highways. Sorry.
Robin Carr, Independent Consultant on Rights Away.
Sorry, could we speak a bit louder? Members of the public can't hear. Thank you.
Yeah, Phil Hobson, Cabinet Member for Community Development, including Countryside Services.
Councillor Brian Strong, a member of this committee.
Councillor Jim Higginson, member of this committee.
Councillor Anne Webb, same a member of the committee.
Councillor Dave Evans, member of the committee.
Councillor Ralph Chapman, member of this committee.
Do we say the members? We've done apologies. Any declarations of interest for what's on the agenda presented to us today? Can I ask members, have they all received their hard copies and as well as their electronic copies presented? Yeah. We've got a few extra hard copies if they seem to have gone astray. Okay, thank you. Now we'll move on to our agenda item number 3, definite map modification order. Thanks, Paul.
Thank you, Madam Chairman. Good morning, everybody. Myself from Highways, Claire Williams, who's MCC Legal Officer, who you all know, and Robin Carr, who is a consultant specialising in public rights of way and has been helping us on this matter, are going to present some evidence relating to the modification proposals. The matter involves
as part of the investigation, in accordance with my instructions, I did conduct a site inspection in December 2014 when I was accompanied by the landowners at the time, for which I'm grateful for the access that they provided. The route under consideration, I believe members have got a plan showing that route is the route shown running north-south on the plan on the screen, and is shown A to J on the copied paper plan that's been provided. Paul's already outlined the nature of the decision that's required, in so much that it's quasi-judicial, and that the decision must be based upon the evidence, the all available and relevant evidence with regard to the status of the route. Matters which can't lawfully be taken into consideration, as Paul says, are issues such as desirability, need, security, future maintenance, or anything of that nature. The decision is purely a matter of whether rights exist or not, and what those rights are. And again, as Paul says, the standard of proof essentially is on balance of probability. The test that Paul set out is that rights be established, or if there's a reasonable allegation that the rights exist, then the authority is duty bound to make an order. The test for confirmation of an order is slightly stronger, in so much as it must be shown on balance of probability that those rights subsist. So the threshold for actually triggering the making of the order is lower than the threshold for actual confirmation. So it's a lower test, which allows it to go through the full process and also allows other interested parties to have an input as part of that process, thus protecting their human rights to a fair hearing, etc. So in that respect, there is arguably a situation where you could end up making an order which ultimately isn't capable of being confirmed, but that's still a correct decision to make the order and allow it to go through the process. Because also, if there's a conflict in the interest in the evidence, and if you've got credible evidence to show that rights do exist, but there's evidence that can't be reconciled against that, which suggests the contrary, then again the courts have ruled that in those circumstances an order should be made to allow it to run through the full process. So the decision that's been sought at this point is the making of the order, or not. With a view to it going through the entire process. So it's certainly not the end of the process. It's very much the beginning of the statutory order process in that respect. Consultations were carried out with all interested parties, and parties were offered the opportunity during those consultations to submit evidence that they consider relevant, subject to the caveat that it shouldn't relate to matters that can't be lawfully taken into consideration, because simply that wouldn't assist in the decision-making process. Now, but by way of a small amount of background to the case, the Monmouthshire County Council is, of course, the highway authority and surveying authority for the area, and as such it's responsible for highways in general, and more particularly the definitive map and statement. And in 2003, inquiries were made with the County Council regarding the status of the route in question. And this led to various proceedings being pursued by the Magistrates Court and Section 56 of the Highways Act 1980, and at that time it resulted in, well, the route wasn't shown on the list of streets at the time. Subsequent investigations by officers resulted in the conclusion that it should be shown as a highway maintained on public expense. So there's been a history of consideration and various reports, etc., over a period of time relating to the status of the way, and ultimately that resulted in a complaint to the Ombudsman regarding a variety of matters by one of the landowners affected, and the Ombudsman looked at the case and closed the file on the matter in March 2014, having been satisfied that the County Council were prepared to reconsider the issue via the process that we're undertaking today. In terms of the legislation, as we said, we've already covered the issue of standard of proof, etc. And as Paul has very kindly highlighted, you've got various different status of rights of way: footpaths, bridleways, restricted byways, byways open to all traffic. In considering this particular issue, in the first instance, we just need to clarify that the term highway is very generic. It's not referring by any stretch of the imagination to just a vehicular way. The definition of a highway is simply a way over which the public have a right to pass and repass. So you've then got to attribute the appropriate status to the route, be it footpath, bridleway, etc. And at common law, we have three classifications of highway, which is footpath, bridleway, and carriageway. And statute has subsequently introduced different definitions and categories within those three. And in particular, with reference to today, we're looking at issues surrounding possibly restricted byway status. So the first consideration that members will have to make is that does the evidence on the whole suggest that the route is actually a public carriageway, in other words, a vehicular highway? And if they're satisfied that that's what the historic evidence does show, you then apply the tests of the Natural Environment and Rural Communities Act, which serves to extinguish or retain rights for mechanically propelled vehicles. If none of the exceptions within the Act apply, then the vehicular rights as far as mechanically propelled vehicles are concerned would be deemed to have been extinguished, in which case you're left with restricted byway. So it's essentially a two-phase test in that respect. Firstly, is the route historically a carriageway? And if it was, then the effect of the Natural Environment and Rural Communities Act. In terms of the evidence that we're going to look at, essentially we're looking at a case based upon common law rather than a statutory period of modern user. So when looking at the evidence, the key consideration is essentially, does the evidence, when taken as the whole, present a picture of the historic reputation of the route being a public highway? It's not necessary for you to determine precisely when that highway came into being. It's very much a matter of evidence of reputation of the route. And of course, if those highway rights do exist, then the principle of once a highway, always a highway will apply, and therefore those rights can only have been extinguished as a result of due legal process. So lack of use over a period of time, or the fact that the route may well not be physically available or anything like that at the moment isn't a consideration. Once those highway rights are there, they are there permanently. And in terms of considering the evidence, perhaps one particularly relevant piece of legislation to consider is Section 32 of the Highways Act, which says that a court or other tribunal, before determining whether a way has or has not been dedicated as a highway, or the date on which such dedication, if any, took place, shall take into consideration any map, plan or history of the locality or the relevant documentation which is tendered in evidence, and shall give such weight thereto as the court or tribunal considers justified in the circumstances, including the antiquity of the tendered documents, the status of the person by whom and the purpose for which it was originally compiled, and the custody in which it has been kept and from which it is produced. So that's really giving the remit of what we should be considering in terms of the documentary evidence, and how we afford each piece of evidence its appropriate weight. Now, in terms of the route itself on the ground, the site inspection did reveal that there are sections of the route which are quite a significant landscape feature of a sunken lane, giving it an appearance of some antiquity, and as we'll see from the documents, this is supported by various historical sources. So there's definitely a very strong physical feature on the ground over substantial sections of the route. Although if you were to go on site today, I suspect that much of that wouldn't actually be physically available to walk in that respect. The photographs that are there are simply some typical sections of the area. They're not meant to be indicative of the entire route.
Robin.
With regard to the documentary evidence that's being considered, just to respond to that point, they were taken from surveys that weren't conducted by myself. I did walk the route. They certainly give it a feel of the general nature of the type of route that you're looking for, whether it's the actual route or not. As I say, physical existence today wouldn't particularly be relevant. It's the historic evidence that we're looking at, but there are if you walk the route, there are substantial sections which are sunken lanes of the route that we're looking at. There's no doubt about that, even if the specific photographs are being questioned. The first documentary source that we're looking at are 18th and 19th century commercial maps. I'm going to combine essentially sections 6 and 7 of my report together here to save duplication of the documentary sources. But essentially these maps were commercially produced maps which predate the Ordnance Survey maps. So they were produced by a variety of map makers, and there were many map makers at the time undertaking this process, because there were various prizes available for the mapping of counties. It should be stressed that they were effectively commercially made maps, many sponsored by subscription of various people. And it would be reasonable to assume that anybody who's buying the maps would expect to be able to use the routes and ways that are shown upon them. That said, some maps are known to have shown both public and private ways, so we can't necessarily automatically say that the inclusion of a route on this map is definite proof that it's a public highway. However, if you take the evidence cumulatively of a number of maps, then that increases the value of them, and they are good supporting evidence. And it would be fair to say that where you've got evidence of a route on these maps, in the absence of evidence to suggest anything to the contrary, then they can be taken as prima facie evidence in support of a route having some form of highway status. And I say that carefully, with some form of highway status. You can't necessarily automatically attribute vehicular highway status, although the majority of the routes that are shown would tend to be now vehicular. I would urge a little bit of caution on taking that conclusion fully. Now we have a number of maps here. There's I'm going to run there's Carey's map of 1805, which actually which doesn't show the route on that, as we have also Teesdale's map of 1829 and Moore's map of 1848. Each of these maps are included to give a full picture of the mapping series, and those particular maps don't show the route in question. So in that respect, they don't provide any evidence to support the existence of rights of way. But it's important that the document set is viewed as a whole, rather than just looking at maps that do show it, which may be deemed to be slightly inappropriate. We've got Price's map of 1823 and the David and Charles map of 1830, both of which show a continuous route through to Trellick Grange. Just highlighted that because certainly when I was conducting the investigation, it can be difficult to get your eye in on the specific route when you're looking at so many maps of different antiquity. But both of those mapping sources show a continuous route running between two other highways and two other places. So, you know, that would be said to be good supportive evidence of it being public, unless there's evidence to the contrary. We then have Greenwood's map of 1830, which shows the southern section of the route and a continuation of Trellick Grange, but the middle section isn't shown. So we've got the section to the north, we've got sections to the south, but the middle section isn't shown. And then we've got Hall's map of 1839, I think that should be 1831, and the Gray and Son map of 1840, which shows the route running through to Trellick Grange, but the southern section is not shown. So we have a combination of different things being mapped over a very similar period of time. So what we can say from this documentary source is that there was a route physically existing at this time. The fact it was a through route is supportive, in the absence of evidence to the contrary, that it has some form of highway status. But what we don't have is a full set of every commercial map showing the route. So that needs to be weighed into the balance of how much value you attribute to those maps. What we can say is, as say, looking at the physical existence of the route and its physical appearance on the ground as a sunken lane in various parts, then these maps support the suggestion that lane is there of some historic origin. Now the Tithe Map. Now there's 2 copies of the Tithe Map for the area. One located in the Gwent Records Office, and the second in the National Archives at Kew. Tithe maps were produced essentially for the purposes of commuting the payment of tithes from an amount of goods and chattels to a monetary value. That their primary source wasn't for identifying public highways. So we have to be careful with the evidential value of documents of this nature. Essentially, highways and routes are often excluded from the valuations, but that wouldn't be because they were necessarily highway. It would be because they weren't subject to the tithe payment. So again, caution needs to be taken when attributing a value. What we do know is that these maps are amongst the earliest and most accurate large-scale maps that are available. So again, whilst we can't necessarily attribute a great deal of value to them in terms of saying whether or not something's a highway, they are good evidence again of showing the historic existence of a route. And we have both of the copies of the Tithe Map here. That's the National Archives copy. And then we also have the Gwent Records Office copy, both of which are showing showing the route, but we can't attribute firm status. Just again, part of that picture that we can say from the early 18th, 19th century commercial maps and the Tithe maps, they are broadly consistent in showing the physical existence of a route at that time. And that's obviously a material factor in your decision. Now, Ordnance Survey maps, it's probably fair to say they are the envy of the modern world when it comes to mapping. We are fortunate in this country to have probably better mapping than anywhere else. But again, they are evidence of physical existence, and many maps from the 1880s onwards, or generally Ordnance Survey maps from the 1880s onwards, do carry a disclaimer to the effect that the showing of any path, track or way should not be taken as evidence of the existence of public rights. So again, this is evidence of the physical existence of a route from which it's possible to draw certain conclusions, but we have to be mindful of the caveat regarding the status of ways shown, and equally, surveyors, when they were carrying out these processes, were not charged specifically with determining the precise status of everything. They had to make various assumptions. They certainly wouldn't be going through the rigorous processes that we do today in determining these matters when mapping the whole of the country. So some caution has to be attributed to this, as with all evidence. It is a matter of perhaps looking at the cumulative effect of that evidence rather than the necessarily the individual documents and what those shown. But what we can say again from the Ordnance Survey mapping is that we do have a consistent feature shown running along the route concerned. We've got the first edition Ordnance Survey map, which shows the route as a continuous route running through to Trellick Grange. We then have a range of 25-inch to the mile county series maps that show the route as a road or lane with boundaries each side running northwards, and then as an unbounded path or track. And the 1886 Ordnance Survey 6-inch map also shows similar features, which again is not surprising because the same surveys were essentially used for producing both sets of maps. The Ordnance Survey didn't necessarily conduct a new survey, just for producing a map at a different scale. They would refer back to the surveys they already had. As we can see, we've got the Ordnance Survey 25-inch 1882, the 1901, which is a composite map. As you'll see from previous ones, we have, as is typical with just about every case you ever do on these things, the route that you're looking at is always on the join in the map. For the 1901, we're fortunate there that it's a composite map where the two sheets have been joined to allow ease of reference. The 1920-21 Ordnance Survey and the 6-inch OS of 1886. Again, they're all showing the physical existence of the route. So we have if we're looking at the evidence as a whole, as we're moving along, we've got a consistency of the physical existence of a road or track running along the route concerned. Not everything shows the route in its entirety, but I think it's reasonable. It would be reasonable to conclude that there was a physically existing road or lane of some sort certainly from the early to mid 19th century in place there, possibly earlier, but from the documentary evidence that we have, we can show that it's existed certainly from the early 19th century. Now the 1910 Finance Act records are a very useful, or can be a very useful source of evidence when looking at rights-of-way matters. Basically, the purpose of the Finance Act in 1910 was to attribute a valuation on all land throughout the country. So it was a massive task and a massive survey, and it was conducted with a huge amount of detail to the extent that it's often referred to as being a second doomsday survey, because it's got so much detail about the land and what existed on the land at the time of the survey. And the purpose of the legislation, as I say, was to attribute a valuation to the land at that time, with a view to, if it was sold at a later date, then the increase in value between valuation circa 1910 and the date of sale could be taxed. So I suppose it's a bit of equivalent to sort of a capital gains type style tax today. Now the legislation, as I say, it was hugely detailed, and a huge amount of work was done on it at the time, but then it never came into full use. So the taxation regime itself was never really implemented, but the work was undertaken. Now, landowners could claim various deductions with regard to the existence of various things, which would include public rights of way, because that would have an effect on the value of the land. And also they could, you find that certain areas weren't subject to taxation, they were excluded from the survey, and that was generally land that was in the ownership of a rating authority. So if you've got something that's excluded, it is generally considered that if that land is in the form of a road of some sort, then that is very strong evidence of the existence of public highway rights. That is not to say that everything that's excluded is a public highway, because of course there were other rating authorities, so land belonging to an education authority or a sanitary district could also be excluded, and you wouldn't attribute a lunatic asylum to being a public highway just because it was excluded. So you've got to look at the actual nature of the exclusion. And equally, you can't say that everything that's excluded is automatically a public carriageway. because there are certainly examples of footpaths with flights of steps on them that are only, you know, a matter of 2 or 3 feet wide being excluded. So you can't automatically conclude that something that is excluded as being a public carriageway. What you can say is that if it's in the form of a through route and it's excluded, then it's good evidence of highway status of some sort, and then we've got to look beyond that. So we've got two means we can look at with the Finance Act documentation, which is a route excluded, or were deductions claimed for the existence of public rights. Now, obviously, the exclusion elements are perhaps the easiest to interpret. The claims for deductions can be harder because the deductions weren't necessarily route specific. It would be a deduction in respect of a whole plot of land. So if there are a number of rights of way across a piece of land, then there would be a single entry in respect of the valuation. So you can't specifically say that it relates to which right of way. So in terms of the routes in question, we have the we have certain sections excluded. The southern section is excluded, which is down here. So the southern section of the route was actually excluded. So that can be taken as very good evidence of the existence of highway rights. The remainder of the route to the north wasn't excluded, but there were deductions in respect of public rights of way across the land. But that does have to be treated with some caution, because there are a number of other paths that cross that piece of land, and we can't specifically say that the deduction applies to any specific route. So that's just showing the northern section of the route going up as far as Trellick Grange as within the land holdings. And then we have the field book entries. And the relevant entry is here. As we can see, the field book contains a specific reference to public rights of way or user, and in that instance we've got a deduction. And in the other land holding we also have a deduction. Now, the next set of documents that we've got to look at are highway authority maps and records, and there's quite a number of these. These all predate the current list of streets. So and it's important to differentiate between the two, because the older highway records are generally documents that were internal to the highway authority rather than on public deposit. The current list of streets is publicly available, whereas these documents were more likely to be internal reference documents. However, I made reference to Section 32 of the Highways Act in my opening comments, and in looking at these documents, we've still got to remember that they were produced by the highway authority, the authority with responsibility for the maintenance of public highways at the time, and they were being maintained as an authoritative record, albeit possibly internal at the time. So they're not, as has been suggested, the view of one person on one day at one time. They are still an authoritative record, and they do need to be attributed appropriate evidential weight in that context. So we've got the 1949 highway records, which was, you see, it shows the route in purple with the reference 5316, although a small section, the southern end, appears not to be shown. The purple line has been crossed out with the word out next to it. So what we have here is a record showing that the route was considered by the highway authority at some point to be an unclassified road by reference to the key, and that and I think the reasonable interpretation of that is at some point there was a decision of some sort to remove it from that record. And once we've gone through the full documentary sources, we'll perhaps address the various explanations as to why it was removed separately. At the moment, it's probably better to just look through each of the records so that we can see what they say, and then we can draw some conclusions a little later on as it's dealt with specifically in the report. The 1952 highway records. Now these are shown as having been reproduced and updated in 1987. It's a composite map showing both public roads and public rights of way. The route has not been marked on the Ordnance Survey as being a highway of any description. So in this instance, we've got effectively it's showing that the route isn't considered to be a highway, but we do need to attach some caution to this record as well, because as we can see, it's a 1952 highway record map which has been reproduced and updated to 1987. So what we don't know is at what point, as to whether it is accurately and completely showing the view in 1952, or whether it takes into account changes between 1952 and 1987, so that when it's been reproduced as of 1987, it is an updated document that shows the current thinking in 87 rather than 52. And from that, we can perhaps look at, as we go through the other records, we can see that that particular record set is more likely to relate to the situation as of any amendments made up to 1987, rather than being specific and cast in stone as of 1952. So we have the 1955 highway records, which show the route as a solid black line with the reference number and a small section not being shown. Black lines being crossed out in respect of the route running northwards. So again, bearing in mind what we just said about the 1952 record, it seems strange that if the route wasn't shown in 1952, it was then shown in 1955 just to have been crossed out, having also been shown on the 1949 record and crossed out. The more reasonable explanation is that the 52 record has got later updates to it, and we've got a consecutive set of records showing suggestions over the removal of the route, although we don't know the reasons why. And we also have some undated highway records, which are notes quite probably referring to processes and considerations in this instance. And with regard to 5316, which is down here, we can see on there that there is a reference to it saying that it's not maintained at all, and see a schedule of amendments. So this suggests there's some thought process going into why the routes are shown on the map, on these maps, and whether they're maintainable. Now, again, from experience, you need to be very careful in looking. Just because a route has not been maintained, or has never been maintained within the memory of the people compiling the document, that doesn't mean that it's not maintainable. So it's a subtle difference between the two. And of course, these records are supposed to show things that are maintainable rather than routes that have been maintained. And this is a common problem with records of this nature, is you inevitably find that amendments are perhaps being made as the result of, with best of intention, to show current maintenance practice rather than historic maintenance liability. And that's not really what the documents are about, but it is an issue that crops up quite a lot. And we have another set of records at Appendix 11, which again is showing the routes have been scored out. That one's, again, it's undated. We're not sure on the exact date of that record. I think we've quite reasonably assumed that 53 is scored out because 53.15 is above it, 53.17 is below it, and the route in between is scored out, and they appear to be in numerical order. So I think it's a reasonable assumption to say that where the black lines are is 53.16. We also have some highway records dated around about 1970. This is a list of unclassified roads, which appears to be from a file of highway returns to central government, believed to originate about 1970. And again, it includes the road, but it's been crossed out. Now, and I think looking at the nature of the document set, we can certainly say that by 1970 it was crossed out because that's the date of this particular record set. But a return of this sort going to government is likely to be in a document that was affected, or it would have, rather than photocopied, it would have been duplicated at the time, and each year the record would be reproduced and appropriate amendments made, rather than it being a specific process repeated and fully compiled each time. There'd be no sense in that. And the nature of the look of the document is one of that it's been duplicated over a period of time. But we can certainly say that as far as that schedule is concerned, that as of its date of around about 1970, the route had been removed again. But what we don't know at this point, of course, is why it was removed. We've also got some highway records around about 1974. This is an undated highway maps using a 1921 Ordnance Survey base, which is believed by the Highway Authority to have been compiled around about 1974. And it shows the route shaded brown, but then again it's been crossed out and annotated without see schedule of amendments. And then finally, the 2008 highway record. This is a further set of undated maps using metric series Ordnance Survey base maps, and believed to be by the Highway Authority to have been compiled around about 2008, showing the route shaded pink and annotated 5316. And these maps are understood to be an interpretation of the 2008 list of streets. Now, I've been very careful in what value we attribute to the list of streets, which is the next document set. Now, the 1988 version of the list of streets does not include the route. There's no dispute about that. But because of the issues surrounding this route and decisions that have been made between the production of the 1988 list and the start of the investigation, including a decision by the authority to show the route on the list of streets, then it's understandable that later documents may well show it. And I think in terms of determining the status of the way now, we need to be very careful as to how much, if any, evidential value you put on the current inclusion of the route on the list of streets, because that is, its current inclusion is a very result of the ongoing dispute, for want of a better description, over the status. So I would certainly urge caution in what we say. What we can say without any doubt is that when the 1988 version was produced, it wasn't considered, it wasn't included, and whether that's right or wrong will be dependent on the evidence previously considered. But in terms of its subsequent showing as a result of the current process of investigation, I think you need to be very careful as to whether you really afford that a great deal of value, because it's a view that has been reached, and that in itself is value, because it's the authority's view at the view as now, but it is, as I say, part of the current dispute. So I do urge some caution in that respect. Now, the definitive map and associated documents. Here we have, of course, this is a set of documents arising from the 1950s onwards, with a specific view to recording the existence or otherwise of public rights of way. It provides conclusive evidence of the existence of the rights recorded upon it, but it's not conclusive as to anything that it doesn't show. So the omission of something isn't evidence that it doesn't exist, but the inclusion is conclusive evidence that something does, albeit that conclusive status can quite confusingly still be shown to be incorrect. It's quite a strange set of circumstances, but on face value, the definitive map can be taken to be conclusive evidence of what it shows. And the initial process of production of the definitive map included public consultation. Maps were sent out to community councils, where effectively local people were asked to claim the rights that they're relying on. So you've got evidence of local reputation of ways being included in the process. Of course, having said that, the route that we're looking at isn't actually recorded on the definitive map. So in that respect, it doesn't provide us a great deal of assistance. However, when we look at the various statements and things that go with it, there are a number of footpaths that are shown linking onto the route in question, and they are described, and the route is described by default in that as linking onto the county road. So that would suggest that one of the reasons it wasn't claimed at the time was because it was accepted at that time as being a county road of some sort. So it was of a high, that may be said of being a higher status than something should be shown on the definitive map, which would be indicative of carriageway status. But again, we can't take that as conclusive because it's not actually shown on the definitive map. So we can't attribute it the conclusive status that we would a route actually shown. But it is good evidence to show at the time that the route was considered to have a public status, and it would be reasonable to assume also that because the definitive map was to show footpaths, bridleways and routes that were roads used as public paths, which is a status which we no longer have, but was of at least a bridleway in that respect. But as the route hasn't been claimed as part of the definitive map process, but is referred to as being a county road, if you take that in the context of that and its inclusion on the 1949 highway record, which is contemporaneous to the process being undertaken, then it would be reasonable to conclude there was some historic reputation of the route being a public road at that time. There were no changes at the stage of the draft map and provisional map recorded on the draft additions and deletions map, and of course the route isn't, as we'd expect, shown on the definitive map. But again, we have various routes linking onto it, which if it has no public status, then some of these would effectively be cul-de-sacs. You'd only be able to walk as far as the route to where it links in, stop, turn around and come back again. And there is a general presumption in law against cul-de-sacs in countryside and rural locations, unless you can show that those paths were going to a place of public resort or public interest, such as a beach or a viewpoint or something like that. And that isn't the case with these. Of course, some of them do continue on as well. It's not every one of them terminates on the route, but there are routes that do, and that again sort of adds to the value of the document set in suggesting that there's some status. And again, we've got on the definitive statements, it's again referring to the termination points of linking onto the county road. Now, the next document set is a set of correspondence relating to the special review of the definitive map. When the special review was being undertaken, which was in part to review the issue of roads used as public paths, because the status was causing some confusion and continued to do so from the 1960s until 2005. So successive legislative attempts to resolve that took took quite a while to deal with. But in Monmouthshire, it appears that the County Council are also considering the status of various unclassified roads and green lanes that were on their highway records. So it's they went beyond the base statutory minimum, and were carrying out a more substantial review in that respect. And the correspondence that's in the bundle, and we have on here, just relates to that process. This is extracts of correspondence that have been taken from the council's files. A full search was done of a large bundle of files, and these are simply examples of the process that was being undertaken at the time in that respect. And there was a suggestion as part of the special review that that the route under consideration be added as a footpath, and it's shown as such on the special review map. Now again, we need to be careful, as I've already alluded to. There was the issue of rights on routes that were recorded as roads used as public paths, etc., were the subject of successive attempts to clarify with legislation, and the first attempts to reclassify RUPs included a suitability test, whether the route was suitable for vehicles. And this was soon challenged in the courts, and the courts ruled in the early 1970s that when determining the status of a RUP, then you couldn't take into account suitability. It was purely, as we have to today, a matter of what rights do or do not exist. The suitability test is not relevant. So,
Robin, will you just for the meeting give the definition of a RUP, please?
Yes, a road used as a public path is it's a public right, a way over which the public have a right to pass and repass. So it's a public highway of some sort, and the definitions are quite confusing. And this is part of the problem: is that it was deemed to have higher rights than a public bridleway, which would suggest vehicular, but then equally it's not necessarily a vehicular highway, and as there's nothing in between, it's somewhat confusing. And that definition, along with guidance issued at the time, led to suggestions that routes that were private roads over which footpaths may exist, or bridleways, may have been defined as roads used as public paths because they had the physical appearance of a road but only had the footpath or bridleway rights over them. Or the other alternative is that it was, as we might describe today, is that it was meant to record what were considered to be perhaps green lanes, which is a term in a legal context. It doesn't have any legal definition for a green lane, so it's perhaps an attempt to record what were considered to be vehicular highways that were perhaps unsurfaced. So this was the whole root of the problem with their classification that took so many years to resolve with successive changes in legislation, which led to blanket reclassification in 2000 under the Countryside Rights of Way Act of anything that was still a RUP to be a restricted byway. So the area of RUPs is difficult and still causes some confusion, but there's no suggestion that it was considered to be a RUP in this context. But I mention the reference to RUPs because if the council, in reviewing their highway records that we've just referred to, the green lanes and unclassified county roads, were applying the same test as they were required to at the time with regard to the reclassification of RUPs, they may well have been looking at a suitability test rather than just the existence of the rights. So, we don't have the benefit of knowing exactly what was going on. We've got to try and interpret the information and documents that are available. So again, as I've said so many times before, we need to treat these documents with caution because we don't know exactly what they were doing. But we do know from past references that they were saying, oh, well, this has never been maintained, so should it be going on as a lower status, which of course isn't a legitimate reason for altering the status there. So we've got a bit of confusion perhaps over the over the document sets. We also have a variety of sales particulars relating to the surrounding land, and these documents refer to various plots, some of which have reference to being fronted onto highways, and some of which that don't. So again, some of it suggesting that the route wasn't considered at the time to be a highway, although again we do need to express some caution, because where there are references to road frontages and roads and lanes, there's no necessary differentiation between public and private, so we do have to be careful. And property sales details, if they specifically mention something as being a public highway, is probably good evidence, but beyond that, we again, as with everything, we need to treat them with some caution. But there is a number of documents there that refer and describe roads and lanes, but without them attributing public or private status. We do have to be careful. Again, we have lots of information relating to the physical existence of the route, but not as much relating specifically to status, which is where we've got to again look at the evidence as a whole and what we can draw from that. And then we've got further document sets relating to the purchase of Panther Farm in 1977, which is another document set. Various plans relating to the surrounding land, which generally show that it wasn't excluded, that the land wasn't excluded from the sale. But again, we have to be cautious here, because this isn't an issue about who owns the land. There is no doubt that the adjoining landowners, if they say they own the land, then the authority's got no reason to dispute that, regardless of the status, because the very nature of the public highway right is it's a right for the public to pass and repass over private land. So if the adjoining landowners claim that they own the land, the simple answer to that is, well, nobody is actually disputing that. There's no dispute whatsoever over land ownership as far as the subsoil is concerned, and the right to sell the land or anything of that nature. The issue is solely as to what rights exist over the land, and of course the right being the right to pass and repass. It's not a physical entity as such. It's the right to pass and repass. So as such, property deeds, etc., do have to be again treated with a level of caution. But there is a whole raft of property deeds that have been submitted on support of this. Further clarification on a number of points was sought on questions arising from these deeds, but no response was provided. So that leads us to that essentially is the evidence that is before the committee for the purpose of consideration, and as set out in the report. And I mentioned earlier reference to various questions which perhaps need to be answered to assist in determination of the case. I mean, there's no doubt that